Hello, everyone. When the former President Jacob Zuma was about to leave the office, he signed off on a multitude of appointments at the National Prosecuting Authority, which were all swiftly undone by the new incumbent Cyril Ramaphosa. Now the Constitutional Court is being asked to adjudicate which of the two presidents acted unlawfully. Ron Simpiwe Mncwabe and Kulegani Raymond Matsenjwa were appointed directors of public prosecutions in the Northwest and Mpumalanga respectively a week before Jacob Zuma left the office. According to Daily Maverick, records show Zuma signed a presidential minute on their appointments on 7 February 2018. He resigned 7 days later without announcing the appointments. When Cyril Ramaphosa took office, he was suspicious of this timing of the appointments of the NPA. He halted these and 3 others Zuma had signed off on. Now the Constitutional Court is being asked to adjudicate on which of the two presidents acted unlawfully, Zuma for making the appointments or Ramaphosa for cancelling them. At the heart of the case is the question when a presidential order becomes final. Mncwabe and Matsenjwa say it's when the president signs a presidential minute, whereas Ramaphosa argues it's when the decision is publicly communicated. Mncwabe and Matsenjwa have applied for their cases to be heard by the Court after their cases were dismissed at the High Court and Supreme High Court of Appeal. They questioned the constitutionality and rationale of Ramaphosa's decision to remove them. In his funding affidavit, Mncwabe said the High Court judge who dismissed his initial in his application erred in his finding by insisting that the appointment should have been publicly communicated to make it effective. It is submitted that it is a matter of unusual public importance that warrants the attention of the court, insofar as it concerns the appointment by the president of one of the most senior prosecuting officers in South Africa. Provincial directors of public prosecutions are the most senior NPA officials in each province and make decisions about which cases are prosecuted. Mncwabe argues his appointment should be considered final because Zuma signed a presidential minute, which was countersigned by the then Justice Minister Michael Masuta and communicated to him via advocate Shaun Abrahams, the former national head of the NPA. Mncwabe argued it was not open to President Ramaphosa to revoke my appointment. Principle of legality dictates that an organ of state may not unilaterally rescind a prior decision, or even if such a decision was unlawful, but must approach a court to have its prior decision set aside. The core question and appeal will be whether, on the undisputed facts, the decision to appoint me as DPP must be deemed to be final. He added that the High Court read in a requirement that Zuma's decision should have been publicized, saying that nowhere in legislation did it require an executive decision to be publicized before becoming final. While it is of course true that the public has a direct interest in the identity of the DPP, that does not entail that the decision of the president to appoint me to that post is not final, simply because there was no contemporaneous public announcement. Matsenjwa also made some similar points in his heads of argument, saying Zuma complied with the requirements of the NPA Act and Constitution when appointing him. Matsenjwa contends that President Ramaphosa's decision to revoke his appointment is unlawful, invalid, irrational, and inconsistent with the Constitution, and consequently should be reviewed and set aside. Matsenjwa is also critical of the High Court decision by Judge D.S. Fourie. The judgment comes down to a single judge's view on the requirements and process for the appointment of a DPP, which view is not supported by Section 13(1)(a) of the NPA Act, read with Sections 179(3) and 7 of the Constitution. In a view of the clear wording of the legislation, Fourie's J.S. reading and imposing of an obligation of the public notification, Section 13(1)(a) of the NPA Act, effectively amount to a legislative amendment. The presidency says Ramaphosa was acting within the law by cancelling the appointments. Pendile Baleni, Director General in the Presidency and Secretary to Cabinet, argued in an affidavit before the court that Ramaphosa got legally advice before the reversal. Baleni said he engaged with the erstwhile Minister of Justice and Advocate Abrahams regarding these proposed individuals, given the seniority, positions concerned, and the issues plaguing the NPA. Baleni also questioned whether the parties were properly informed of their appointments, saying Mncwabe was informed via WhatsApp and telephone by Abrahams, not the presidency. Advocate Abrahams also sent him a copy of the presidential minute purporting to appoint him via WhatsApp Messenger. A hard copy of the minute was also apparently sent to Mncwabe in November 2018 on the same day. 7 February 2018, Mncwabe received another phone call from Advocate Abrahams in which he made mention of the political climate at the time and informed the applicant that he must await communication of his appointment from the president. The communication from the presidency did not come and Zuma resigned a week later. The vacancies that Matwenja and Mncwabe were meant to fill have since been filled by other people, and the presidency said undoing these appointments will cause problems within the National Prosecuting Authority. What's your take on this one, people? Who do you think acted unlawfully? Was it President Cyril Ramaphosa or President Jacob Zuma? Thanks for watching. Please subscribe for more news.